A very good afternoon, ladies and gentlemen. Thank you for tuning in. Hope you are having a pleasant day. It's great to be back again this week with another episode of the Strata Talk Show. With that, I would like to welcome everyone to the 52nd episode of the Strata Talk Show, brought to you by the Excel Academy of Real Estate. To our new viewers, in this talk show, we'll be discussing issues and cases related to the management of stratified developments with various industry professionals. Joining us today, we have Mr. Patrick Sebastian, who is an advocate and solicitor of the High Court of Malaya, to speak on the topic of powers and duties of GMB and GMC. If you have any questions for Mr. Patrick Sebastian, feel free to leave them in the Facebook comment section below, which will be addressed in the Q&A section at the end of the show. Without further ado, join me in welcoming Mr. Patrick. Welcome, sir.
All right, thank you. Good afternoon to each and every one of you. Right. Today's topic is about the powers, the duties of the joint management body as well as the joint management committee. Now, as we are all aware, or we ought to be aware, in a stratified development, it is possible to go through three stages of management. The first is the developer who manages the place from the time the building starts getting constructed. And of course, at that point of time, everything is under the developer's head, or on the developer's head, I should say. Then subsequently, once the building is completed and vacant possession is being given out to the purchasers as per the sale and purchase agreement, which will be 36 months from the date of signing of the SPA. What happens next is the developer manages the place until the first AGM of the JMB is conducted. And the first AGM of the JMB is conducted 12 months after the vacant possession has been delivered. So for a period of 12 months or more by extension if necessary, the developer will be managing the place. The developer will then hand over to the JMB, and the JMB is formed at the first AGM of the JMB, which the developer will call for. And once the JMB has been formed under the first AGM, the immediate duty of the JMB is listed down in the statute, your Strata Management Act. Essentially, it will be to take over everything from the developer, including the maintenance account, the sinking fund account, the strata roll, building plans, and various other documents. These will also include insurance and other things. Now, a very important document in the handing over from the developer to the JMB is Form 4. In Form 4, a full list of all documents, contracts by service providers, manuals, operation manuals, and things like that will have to be handed over to the JMB. Now, the first duty of the JMB or the JMC is to ensure that every relevant document is handed over. My advice to a lot of people is, if the developer does not hand over complete set of all relevant documents, then the JMB should not take part in the handover. They should say, all right, there is a partial handover. We will not accept a full handover, because once the developer hands over everything, he washes his hands, cleans, and say, goodbye, it's all over. I've handed over, my job is done. But the JMB may be left hanging in the air. Now, after these handovers, the JMB's first job after the first AGM under Section 22 is to elect a joint management committee. Now, at the first AGM, the members who have vacant possession, they only elect committee members. They do not elect the chairman, secretary, treasurer. They just elect committee members. So you have to decide how many people are there going to be in the committee. Minimum of three, not exceeding 14, if it's depending on how large the development is. And then at a separate meeting, the first meeting of the JMC immediately after the election is to determine among themselves who will be the chairman, who will be the treasurer, who will be the secretary, and the rest of the committee members. Then they will have to go through all the documents that the developer is supposed to hand over. Right. Now, the reason I chose the topic today is because, as many of you are aware, I handle a lot of strata matters. And one of the key elements is what are the powers and duties of the JMB? What can and what can't they do? While people like to ask the question what they can do, they don't seem to be asking the question what they cannot do. So it is wise that if you are in the committee, the first thing that you do is to turn to Section 21 of the Strata Management Act and look at the powers and the duties of the JMB. These are their powers. This is what they can do. This is what they cannot do. Now, in the famous or infamous Rajawali case, Vernon Ong, who was in the Court of Appeal, said that the JMB is a statutory body. Its powers are circumscribed by statute. The word circumscribed here means it's limited, right? It's surrounded by statute, and they can only do that which is expressly stated in the statute or which is impliedly necessary to carry out the express powers. If a power is not stated in the section, then they do not have the power to do so. So, therefore, the JMB's powers are limited. Section 21 clearly tells us what are the powers of the JMB. 21 sub 1 talks about the power, and this is followed up by a number of things. So please take note of these things. If you have your statute book beside you, I'm sorry for that. If you have a statute book beside you, you can look at the duties are stated in subsection 1. The powers are stated in subsection 2. Right? Now, there are certain things that we have to note that after the JMB, once strata titles are ready and 1/4 of the aggregate share units have been issued, then the JMB will have to hand over their responsibility to the MC. To many people or to the layman, there seems to be no difference between the powers of the JMB and the powers of the MC. It looks like it's handing from one body to another body who is going to do the same job, which is managing the place. However, this cannot be further than the truth. The Rajawali case itself was based on this when Vernon Ong compared the powers of the JMB to the powers of the MC. And while it is specifically stated that the MC has a power to determine and vary the rate of maintenance charges, the JMB only has a power to determine the maintenance charges and not to vary it. It was on this basis that the Court of Appeal said that the JMB had exceeded their authority by varying the amount of maintenance charges, especially in a mixed development. So, such fine differences are extremely important because it can determine between the right and the wrong of the parties. So, you need to take note of this. This is very important. The other thing is, apart from the fact that the JMB cannot vary the maintenance rates between the different types of parcels in a development project, The JMB also does not have the power to enter into contracts exceeding 12 months. Now, it doesn't say 1 year, it says 12 months, right? So, this is also something that is relevant for us to take note of. So, join JMC members. If you're a JMC member or you are one of the property managers who is advising the JMB, you need to be aware that you cannot enter into contracts exceeding 12 months. All service contracts have to be renewed on a year to year basis, right? Thirdly, the JMB does not have the power to borrow money, neither do they have the power to charge any of the properties or use any of the assets for purposes of a loan. Since they cannot borrow, then they cannot charge assets as well. I've come across cases where committee members have said things like, there was not enough money in the maintenance account, so I'm the chairman, I'm the treasurer, I'm secretary. We advance monies to the JMB to help to maintain the place. Well and good. It's good of you. It's very kind-hearted. However, we are we are here talking about law. Whether you want to call it an advancement or borrowing or a loan, doesn't matter. As William Shakespeare said, a rose by any other name smells just as sweet. Does the JMB have the power to borrow? If it has, where is it stated? If I were to look at the powers in 21 sub 2, it says to collect charges, to collect contribution to sinking fund, authorize expenditure, recover from parcel owner any sum expended, purchase, hire, or otherwise acquire movable property, employ the services of maintenance and management, make additional bylaws, do all that is necessary for the performance of this. Nothing is mentioned about borrowing. So obviously they cannot borrow, right? If you were to compare this with the powers of the MC, now if you look at the powers of the MC, then the MC is very different. If you look at section 59, the duties and powers of an MC are stated. In section 59, subsection 2, okay, so it says in paragraph H, to borrow monies required by the management corporation. And I, it says to secure the repayment of monies borrowed by it by negotiable instrument or by charge. So there are two additional powers given to the MC, which is not given to the JMB, which is to borrow money and to give security for that loan. Only the MC can do that. Okay? Now, regarding the contract which cannot be exceeded for 12 months, some of you may ask, where is this mentioned? Okay. This is mentioned in section 21, subsection 3. So please take note of that. It says, the joint management body shall not enter into any contract relating to maintenance and management, okay, etc., for any period exceeding 12 months. Now, the other thing that they cannot do is, the JMB cannot buy immovable property. The MC can buy immovable property outside the development area, not within the development area. So please note, neither the JMB nor the MC can buy any of the parcels, because that would be a conflict of interest. You buy the parcel, then you have to pay maintenance yourself. Surely you're not going to sue yourself, right? The MC, not the JMB, MC is allowed to buy property, immovable property outside the project development area, right? Maybe for extra car park, for example, and this will be regarded as common property. Okay, this is allowed for MC, not for the JMB. JMB can only acquire movable property, not immovable property. Okay, so see, these are the powers and limitations imposed on the JMB. I assume that in years to come, if the full force of the Strata Titles Act is enforced, whereby at vacant possession you also give strata title, the JMB will cease to exist. We will go straight into the MC after that. But meanwhile, we still have these problems surrounding us. Now, moving on from here, Section 22 talks about the JMC, and Section 22 clearly says that the JMC is to carry out or perform the JMB's duties. They are to conduct the JMB's business on its behalf and may, for that purpose, exercise any of the powers of the JMB. Now, again, going back to the Rajawali case, in the Rajawali case, Vernon Ong was also confronted with this because one of the things that was done was at a AGM of the JMB, a unanimous resolution was passed that they vary the maintenance rates for different types of parcels, and the JMC be empowered to determine the rates. So we have already seen the courts have said JMB has no power to vary the maintenance rates. Next, the court also went on to say that JMB cannot delegate such powers to the JMC. The law required that the JMB must make the decision and the JMC must only carry out that power. So, in other words, Section 22 is interpreted where it says here, and may for that purpose exercise any of the powers. The word exercise was interpreted as to carry out the powers of the JMB. The JMC does not have the power to make the decision, they only carry out. Now, this puts a very serious block in this situation because it means the JMC has to get back approvals from JMB either via AGM or EGM before they can proceed to carry out certain things. And the JMB itself, we know the JMB can only decide via AGM, EGM. So one judge asked me the question during a trial, are you suggesting that for every small thing, the committee has to go back to the main body, call for an AGM, call for an EGM? Many people think logically it doesn't make sense. But let me put it this way. If this is what the statute requires, number one, then so be it. You cannot do anything about it. Okay, if this is what the statute says, then this is what has to be done. Number two, not everything is decided at AGM and EGM. We need, and this is where you need to draw the fine line. There is a line between maintenance and management. When it comes to the day-to-day maintenance, obviously the JMC is authorized by the JMB and by statute to carry out the necessary things to maintain the place. Right? I'll come to that reason shortly, but they have the power. So, for example, if something goes wrong, your security system goes wrong, your access card system is not working, or like some places they are using the RFID system and suddenly it breaks down, the computer breaks down, you need to change the laptop, in which the whole thing is programmed. You do not need an AGM or an EGM to make such changes. Such changes can be determined by the JMC at a JMC meeting, but which will be reflected in their report to the JMB later. So we must be clear about that. You have emergency breakdowns. There is a need to update, upgrade. The word used is upgrade. Then you may do so. But if you are going to make a major decision, example, you are using access card system, and let's say you find out or you discover that a lot of people are cloning the cards, and because they're cloning the cards, the system is going haywire. A lot of people are coming there, and a lot of strangers are there. Residents are lodging complaints, and you want to overcome this. And now you want to change from your access card system to the RFID system. So you want all car owners to get these RFID stickers. Now that is not an upgrading, that is not a maintenance issue, that is already a major change. In such major changes, you will need to get the approval of the AGM or EGM. The JMB must make that decision. The JMC can do this. They can do the preliminary work. For example, they can prepare a report saying the advantage of the RFID compared to access card, the disadvantages, the cost factor, um, quotations from three different contractors, and submit all these to the JMC, and the JMC then can bring this up to the JMB, and the JMB can make the final decision. Please note, JMC is not a board of directors who decide how much profit the company is going to make and things like that. The JMC is merely managing the place on behalf of the JMB. Ultimate authority rests with the JMB, not with the JMC. The JMC is not a board of directors. They are there to look into the day to day affairs of that development area. That's one thing. So we can draw this clear line between the two of them. It is not the same. Additionally, right, so we must also note that if the JMB does not have the power to do something, then it cannot authorize the JMC to do so. This is the third ground of decision in the Rajawali case. So the first ground is JMB has no power to vary the rates. Number two, right, the JMB has no power to delegate that responsibility to the JMC. The JMC only has a power to carry out the functions of the JMB. They do not have independent powers of their own. Thirdly, as Vernon Ong highlighted, if the JMB does not have the power to do something, it cannot authorize the JMC to do so. So members of the JMC, please check whether, to this point, what I can summarize is, please check out on whether, first and foremost, the JMB has power to do certain things, keeping in mind that they are not a board of directors. Do they have the power? Check section 22. Check other relevant sections. Once you have checked out these sections and you are comfortable to see that, yes, we can do it, then the next question is, can you simply delegate the responsibility to the JMC to do it? There are cases where I've seen some of the chairmen will say, "Oh yeah, I know what to do. I know what to do. You all don't need to tell. I will do everything." Sorry, Mr. Chairman or Mr. Secretary, whoever you are, that's not how it works, right? If you don't get, you cannot delegate to one person and let the person make all the decision. That is also wrong. So you must know what can be delegated. What can be delegated is a day-to-day work. The day-to-day. That's why there are two words being used: maintenance and management. So the maintenance part, the JMC can take care of that. They maintain the place. So whatever arises out of maintenance issues, day-to-day basis, right, upgrading, repairs, and things like that, yes, JMC makes a decision, let them tackle it. However, if it's management issue, it has to be determined by the JMB via AGM or via EGM. Furthermore, we have to realize that there are certain things that need either a special resolution, absolute majority, or a unanimous resolution. If you do not have this, then you have a serious problem at hand. A good example is Section 70. So we can look at Section 70 now and see what it says. A very interesting point stated by Section 70 is in subsection 2: a management corporation, which includes the JMB, may by special resolution make additional bylaws or make amendments to such additional bylaws for regulating the control, management, administration, use, and enjoyment of the subdivided building or land and the common property, including safety and security measures. Details of any common property of which the use is restricted, keeping of pets, parking, floor coverings, refuse control behavior, architectural and landscaping guidelines. Okay, so Section 70 clearly lays that there are certain things which need a special resolution, and without that special resolution, it cannot be carried out. So take note of that. Top of the list is security and safety measures. Are we going to make any additional rules, any additional bylaws, or are you going to make any amendments to such bylaws? Right? So this has to be taken into consideration. Now, sometimes people say, how do I differentiate between maintenance and management? How do we do that? Is it easy to make such decisions? Okay. Now my answer is it's not. It's not. Let's face it, it's not easy. For example, if you were to look at your schedule, let me turn to the schedule and show you. This is the third schedule, which provides under the Strata Management Maintenance and Management Regulations 2015. It says here in clause 3, functions of the management corporation. The management corporation shall maintain in a state of good and serviceable repair, and where necessary renew or upgrade the fixtures and fittings, lifts, installations, equipment, devices, and appliances existing in the development area. Now, please note it talks about fixtures and fittings, lifts, installations, equipment, devices, and appliances. Sub 2, maintain, repair, and where necessary, renew or upgrade sewers, pipes, wires, cables, and ducts. Okay. Now, this is where we can draw a clear line. So, guideline is given in the third schedule, where it states here in the Maintenance and Management Regulations 2015, right? To maintain in a state of good and serviceable repair, where necessary, renew or upgrade. Okay. So maybe there can be a guideline for us. You have to determine, are you merely upgrading? Are you merely renewing? Right? Or are you introducing something new into this? Is it going to involve major expenses? If it involves major expenses, then it might have to go through the JMB. Do tenders have to be called for this? And what is the budget allocation? How much do you expect it to cost? Now, in many places, depending on where you are, whether it's Selangor, KL, Subang, PJ, it's important to note that different COBs have got different guidelines. They say if your expense is below this amount, the committee can make the decision. If it is above this amount, you need to bring it to the AGM or the EGM. And if it's above a certain amount, you will even need to get a quotation from at least 3 different service providers to determine which is the most suitable. So there is something that has to be considered. So these are some of the problems that we do face, right? These are some of the problems that we do face. Um, I've come across cases where the access card system has failed, and when they want to upgrade, the service provider comes and says, this is already obsolete, 20 years old, 10 years old, 15 years old. You know, you can't go and upgrade this, you cannot renew this. Spare parts are no longer available. You would say most of the systems nowadays last only for 5 years, maybe 10 at the most. So why not you change it? And when they tell you to change, you'll say it's the change also involves an upgrade. The main thing you have to ask them is how much is it going to cost? If it's going to cost a certain amount, decide. Is it something with the JMC can determine? Is it something which you need approval from AGM, EGM? Do you need to call for tenders? My advice to you, if you're in the committee, is you actually consult the COB and ask the COB to let you know what is the lines given, financial lines. Up to what point the JMC can make the decision on their own. And then the second stage of getting AGM, EGM approval, third stage of calling tenders. So you can get guidelines. Every COB has the guidelines. I can't tell you what the guidelines are because different COBs have different guidelines. So we did one matter in Ipoh and also a matter in JB where the guidelines are a bit different because they're all different places. The cost of living in Ipoh and JB is of course different from Subang and KL. So that's why they have these varying guidelines. So my advice to you, JMC should seek the advice of the COB, get the figures. Once you get the figures, then it will be very helpful because then you will not be seen to be breaking the law. The other thing to note is while the JMB itself has got a lot of immunity, the JMC does not have such immunity. If there's breach of duty by the JMC members, then there is a possibility that they may be sued. They may become liable. Of course, courts are not very happy to see individual JMC members being held liable, but there are occasions when that has happened, especially when it comes to preparing the accounts. So if you look at the accounts and go back to the relevant sections here, let me highlight to you very briefly. Section 26 talks about duties of joint management body in relation to accounts. And in subsection 5, 26 sub 5, it says, if the joint management body fails to comply with subsections 1, 2, 3, or 4, every member of the joint management committee commits an offense and shall on conviction be liable to a fine not exceeding 250,000. Of course, you can have a defense which is given in subsection 6. The offense was committed without your knowledge and you have taken all reasonable precautions. You have carried out your part of the duty diligently. So this is an issue that a committee member must keep in mind, right? Please also note I must give this advice that the courts are not bound by what the COB says. The courts are not even bound by what the Kementerian Perumahan says, because the courts have held, the federal court in Malaysia has held that whatever advice given by the COB or by the Kementerian Perumahan are merely opinions and they are not the law. In the Inab Shahil case, you may have read about Inab Shahil. He's a person who runs a homestay in many of the more exclusive areas like Mount Kiara, Sri Hartamas, and also in KLCC areas. He runs homestays. Um, he had written to Kementerian Perumahan whether, right, in a service apartment in a commercial property, whether homestay can be allowed. And the Kementerian Perumahan did reply and say, yes, it can. However, in the particular case concerned, the JMB had already passed a resolution not allowing short stays, daily stays, and weekly stays were not allowed. They made an amendment to the bylaws, and in this amendment, getting the appropriate majority, they got the appropriate majority, and the bylaw was amended. So he challenged it in court, and the federal court said that the Strata Management Act is a piece of social legislation. It's meant for the social governance of the people there. Even though it is a commercial property, service apartments, if the MC or the JMB passes a resolution saying that we don't want daily stays, we don't want weekly stays or short stays, then the law must respect that decision. And that the opinion of the Kementerian Perumahan was not binding. So I will still advise to go and get advice from the Kementerian Perumahan, but keeping in mind that you must get the advice of a lawyer perhaps, or you need to check the statute itself to make sure that you are within the four walls of the act. You do not exceed your power. It is better to err on the side of caution rather than get sued subsequently. So this can become a major issue for each and every one of us. So my advice to you is be careful. The SMA is not a complete statute yet. There are many gray areas and it, it can be hazardous, but I think if it is planned well, it can be good, right? If it's planned well, then it can be good. The JMB can do well. There are many development projects I've seen which are run very excellently. There's cooperation from all. And finally, I want to say this: the JMB, the JMC must not be slow, must not be shy to take action against defaulting members, right? Of course, we can say he's my neighbor. I don't know how to sue him. If we are going to manage a place in this way, then you're going to end up in misery. If you are in the committee, then it's your duty to ensure that sufficient money is collected to enable the place to be maintained well, to be kept in a state of repair at all times. So, like in one case, the judge told the existing JMC, he said, we are not able to do much. The lawyer said, we are not able to do much because the owners are not paying the maintenance. So the judge turned around and said, all the more reason why you all should make way and let the new JMC fields come in, which is what the plaintiffs are asking, which is what I was asking. I was saying they are not fit. Look at the way the place is run down. They are not fit. The place is a very good, nice place. It can be luxurious, value can go up, but because it is so badly managed, right? The place is going down the drain. The value is going down, leaking everywhere. So make way. And the judge said, and I told the judge, precisely, if you think that you cannot collect the maintenance, you're unable to collect, people are not cooperating, either you take legal action or you quit. That's all. If you stay on without taking legal action, without doing something about it, then I think it's only fair that you be liable for it. You cannot say, please do not say, I have clients, my own clients who come to court and say, so this thing is not paying any money, I'm doing a voluntary job, nobody else wants to do the job. Fine and good, nobody is saying that. But at the end of the day, you have accepted the responsibility, you have to do it. I always say this, a responsibility is voluntary so long as you have not accepted it. Once you've accepted the responsibility, it is no more voluntary, it's a duty. It's voluntary in the sense that you cannot be forced to take it. Once you've taken it, it becomes a duty. So you have to carry out your duties. You have to do what is required by the law. The law empowers you as a JMB, JMC to take action. So you need to take that action. You cannot say you don't want to do it. Well, that's about all that I wish to say. I thank you very much to all of you for listening in today, for hearing this. If you have any questions, I'll be very pleased to take on your questions. Thank you. Thank you.
All right. Thank you so much, Mr. Patrick, for that talk. We now know the responsibilities held by the GMB and MC. So now we'll move on to the Q&A segment where you will hopefully clarify any questions you have on today's topic. So first off, we have a question by Ahmad Rahimi. Boleh ke AGM minta residents tambah duit, contoh RM120 per month additional from sinking fund sebab new MC dapati sinking fund tiada duit sebagaimana audit dia buat. Should I go to the police, or should I do a police, should I make a police report by for forensics account by COB? Please advise.
Okay. First of all, there are two parts to this question. Now, it is the duty, right? It is the duty of the JMB to ensure that there is sufficient funds to pay for all the necessary expenses, whether out of the maintenance fund or out of the sinking fund, right? So this is the duty of every owner to pay for this maintenance. Now, there is a provision in the Act. Okay, there is a provision in the Act, in the SMA, that where there is insufficient funds, let's say maintenance, maybe during the developer's time, he could have maintained the place, maybe partly using his own money. And because they are using their own money, when they hand over to the JMB, JMB finds that there is not enough money. Tak cukup wang. Okay? So, kalau tak cukup wang, what is to be done? Okay? Now, a very simple way of doing it is you shouldn't have a shortage because you come with a budget. Let's say your budget is 50,000 sebulan expenses. Then you take the total number of share units, total aggregate share units, divide the 50,000 over the share units, times by individual share units, you will get the amount to be paid by each person. Okay. If, however, maybe due to certain emergency expenses or extra expenses, you have shortage of funds, then the law provides very clearly that every owner gives an implied undertaking or guarantee that he will meet the shortfall. He will meet the shortfall. but proportionate to his unit, proportionate to his parcel. This is provided in section 33, subsection 1 and 2. Okay. So there is an implied guarantee. Okay. Kalau wang tak cukup, shortage 10,000. So 10,000 divide by the total aggregate share units in the project times by my parcel. I have to pay. You tak boleh cakap, kenapa pula saya nak bayar? I already paid my maintenance charge. Tak boleh. You tak boleh cakap macam tu. There's an implied guarantee. Every owner must meet the shortfall. Number one. Number two, there shouldn't be a shortfall in the sinking fund. Why? Sinking fund is not a separate fund from the maintenance. Of course, it's kept separately, but the sinking fund is calculated by saying 10% of your maintenance charges, what you charge for maintenance, goes into the sinking fund. So the sinking fund is always 10% of your maintenance, right? And the sinking fund is only used for specific purposes, major repairs, maybe a major breakdown of the lift. You need to paint the whole building again. You need to change the rooftop of the building. Those kind of major work only you touch the sinking fund. So by right, in many developments, the sinking fund money will be a lot because day to day you're only using maintenance account. You don't touch the sinking fund money. And to touch the sinking fund money, you need a resolution at an AGM or an EGM. Jadi, my advice to Encik Ahmad Rahimi is, you periksa balik semua minutes of previous AGM. Were there any resolution authorizing the use of the sinking fund for any major work? Kalau tak ada, then you make the report as you suggest. Do the police report, ask the COB to do a forensic audit. Macam mana there can be no money in the sinking fund. Maintenance fund shortage, I can understand. Sometimes your expense exceed your income. Not everybody pays. Okay? Even using the formula I'm giving just now, bukan semua orang akan bayar. Kalau, 30, most of the time, 40-50% only paying, for the others all free ride only. Okay lah, access card tak boleh pakai, letak kereta di luar, jalan dalam. But they are still staying there. You still have to maintain the place. So, maintenance, I can understand. Sinking fund, no. What should be done now is you can see what is the amount to be paid for the audit, and then you divide by the aggregate, and then say for each parcel owner, this amount they have to contribute towards the audit fee, and then get the thing done. That is my advice. So check back the minutes of previous AGMs, how the sinking fund was utilized, whether there was a resolution to utilize it. Kalau tak ada resolution, they cannot touch the money. They cannot touch it. Right?
All right. Thank you, sir. Next up, we have a question by MK Anwar Rangkuti. Question is, adakah lampu jalan dalam kawasan strata dikira sebagai fixtures yang perlu dibaiki oleh jawatan kuasa pengurusan?
Yeah. According to the third schedule, right? The third schedule, jadual ketiga will uses two words, fittings and fixtures. So I would think that in this matter, it doesn't matter whether it's a fitting or a fixture. Purpose of using the word fixture is for purposes of National Land Code. Under National Land Code, a fixture becomes part of the land. And when it is sold together with the land. Walau bagaimanapun, in this case, for purposes of maintenance, whether the lamp is a fixture or a fitting really does not matter. But since it is actually permanently attached, right? And there are two tests for fixture. Whether it's permanently attached, and two, whether it's meant to be permanently attached or to be removed. I think both of the answers will say it is meant to be a fixture, right? But it doesn't matter. It can be a fitting, it can be a fixture. In any duty, in any way, it is the duty of the JMB to repair it. Because the jalan dalam kawasan adalah dikira sebagai harta bersama. Yes.
All right, awesome, sir. Next, we have a question by Ikmal Jamal, VP with Strata. I assume is vacant possession. Do developers still need to conduct AGM within 12 months after vacant possession?
Okay. There are two ways in which uh, management is conducted. The one I mentioned earlier is the standard one where developers management period, JMB, and then followed by MC. Walau bagaimanapun, if before the vacant possession is delivered, the strata register book is already open, right? Strata register book is already open. Then, according to the Act, under the Strata Titles Act, the moment the strata register book is open, the MC automatically comes into existence, right? So MC akan terbentuk secara automatik sebaik saja daftar strata dibuka. So once the strata register is open, before VP is given, no need to for a JMB. Sebab MC sudah pun dibentuk. The MC is already formed. However, the MC will not come into active function yet. What will happen is the developer will manage the place on behalf of the MC until one fourth of aggregate share units have strata title. When one fourth of the aggregate share units have strata title, they have to call for the first AGM of the MC. Then the MC will take over, right? But the MC is formed when the strata register is open. So if you tell me VP with strata, artinya strata register already open. Whether got
Oh,
one fourth or not, I don't know. Right? If got one fourth already, they have to call for first AGM of MC, hand over the MC straight away. No need for JMB anymore. Right?
all right. Thank you, sir. I believe this one will be our last question for today from Lawrence Pikerman. MC once formed, the new MC committee members have to change the accounts and bank from JMB to MC. What happens if the MC does not do this even after 24 months? Example, did not change SAJ ownership from JMB to GMC. Are they legally liable?
Um, can I know what is the SAJ they're talking about?
Um,
You did not tell what the SAJ is. All right. Number one
not
is
sure. Just let me check.
there is no necessity to change accounts in bank. They just take over. You can just take over. So from the developer hands over to the JMB. All that the JMB does is they get their first AGM minutes, they give their name to the COB. The COB then issues a certificate to the JMB with the certificate, and then the first AGM, and then the minutes showing who are the office bearers, chairman, treasurer, secretary, and who will be the signatories. They just go to the bank. They can maintain the same account, just change the signatories.
Mr.
Likewise,
Patrick, sorry.
hmm,
SAJ is apparently a developer.
oh, the developers. Okay. Then from the JMB, when the JMB hands over to the MC, the MC also does the same thing. The MC gets a certificate from the land office, Pejabat Tanah dan Galian, because MC is formed under land office, not COB. And then they call their first AGM, minutes of the first AGM, resolution as who will be the signatories, who are the office bearers. Take all these to the bank and just change the signatories. That's all. You actually do not have to change the bank account. The bank will automatically change the account to the other side. So that's all you need to do. Unless the MC decides, maybe the MC is different from the JMB. Lah. Maybe the JMB, because they like Maybank, they go and take a Maybank. You all like public bank, you all want to go and take public bank. Then you want to change, then you should change. Otherwise, I do not see an issue there, right? I do not see an issue. However, if the signatories are still the old signatories, then this is wrong. Then this will become wrong. That should not be done. For example, you cannot be going back to the developer asking the developer to sign every check when the JMB is already there. That will be wrong. Okay, that will be wrong. Because if you look at the rules for JMB, okay, maybe if I read what that section just says, okay, so all that it says here is a joint management body in section 23 shall open and maintain a maintenance account with a bank or financial institution. That's all it says here. Okay, so that is what they do. So they can just take over from there, or they can open a fresh new one. But if the signatories have not changed, then and if the developer is still doing the work, then something is wrong. Then they will be legally liable. Then the committee members will be regarded as not having carried out their duties. Right?
All right. I believe Mr. MK Anwar Rakuti added one more question. So let's have a quick one. Adakah pembaikan naik taraf, fitting dan fixtures ni wajib dapat kata putus dari mesyuarat agung?
Ya, di sinilah perkara dia. Kalau dia itu adalah penyelenggaraan atau penyelenggaraan saja, jadi jawatan kuasa tidak perlu mendapat keputusan dari mesyuarat agung. Tetapi kalau ia adalah perkara mengenai pengurusan dan bukan penyelenggaraan atau penyelenggaraan, mereka perlu mendapat kata putus dari mesyuarat agung. Naik taraf ini mengikut beberapa COB, kebanyakannya adalah mengenai kerosakan. Bila sesuatu itu rosak, you kena membaikinya. Kadang-kadang you tak boleh baiki sebab barang itu sudah barang yang lama. Terlalu lama, mungkin 10 tahun, 15 tahun, spare parts tak boleh dapat. Jadi kalau dalam keadaan itu, you naik taraf itu hanya membawa satu perkara yang sama tapi baru. Itu sama. Sistem yang sama tapi baru. Misalnya, dalam satu kes, dia menaik taraf, sistem lama itu menggunakan jari dan juga kad. So, you pakai kad, you pakai jari. Tapi bila sistem itu sudah rosak, dia kata, service provider kata ini tak boleh repair. Sudah terlalu lama, 12 tahun. And then during the earlier repair, most of it, they didn't use original spare part. They use spare part from China. Jadi, dia kata, you cannot go and repair now. You repair pun tak guna. You waste time only. Dia boleh clone lagi. So, he said, the better thing is, kad, jari, muka. Jadi, so, is this something new altogether? I don't think so. It's just an upgrade saja. It's just an upgrade. Jadi, mengikut jadual ketiga, kalau you just naik taraf saja, maintenance, penyelenggaraan atau penyelenggaraan, itu tak perlu dapat kata putus dari mesyuarat agung. Tetapi kalau itu adalah satu perkara yang baru, perbelanjaan yang tinggi, ya you perlu dapat kata putus. Katalah, you nak upgrade pun, upgrade itu 50,000, 100,000. Jawatan kuasa tak boleh buat keputusan. Kena dapat kata putus dari mesyuarat agung. Ini bersama dengan perkara berapakah belanja, sebagaimana yang saya kata tadi. Ada 3 tahap. 1, JMC boleh buat. 2, you kena kata putus. 3, you kena dapat tender dari 3 service supplier. Begitu caranya. Dari COB yang berlainan mempunyai standard yang berlainan. Yes.
All right. Thank you, Mr. Patrick. I think that was the last one.
Okay.
So we have now actually reached the end of this talk show. Once again, I would like to really thank you for this session and sharing your insights today. To those celebrating, the team at Excel Academy would like to wish you Eid Mubarak. Have a joyous one. And we all hope to see you in the next one. Thank you.
Thank you. Thank you all for joining in today.